Good evening, esteemed doctors and medical professionals joining us for the Medical Negligence Note to Healthcare Professionals webinar session. IIHS prides itself on being Sri Lanka's pioneer international university learning center with a history of over 2 decades, where local and regional students gain opportunities to access the health education workforce worldwide. IIHS has provided remarkable opportunities for South Asian healthcare professionals to be equipped with knowledge and be transformed into experts. Moreover, it has never failed to encourage and help our students to inspire a lifelong passion for learning and to pursue a better life and a bright future. IIHS has created international pathways for professionals in Sri Lanka, ranging from Australia, New Zealand, the United States of America, United Kingdom to Malaysia. Being one of the leading private healthcare training organizations whose vision is to transform people, community, and landscape through innovation, we are ecstatic to walk you into the opportunities provided by IIHS. Today's webinar is focused on escalating the awareness of medical negligence in current healthcare practices and improving the safety measures that can be taken towards overwhelming medical negligence, sponsored by the MBA program in collaboration with the Coventry University, UK. Let us now have a look at the corporate video.
It always starts with a thought. A simple thought gives life to inspiration. It is true that over 100,000 women migrate as domestic workers. But being in a country with a high literacy rate, why not export skilled labor? A problem to which we found a solution in 2002. And this story is about that solution. To transform people, community and landscape through innovation is our vision. We create smart people for a smart world with diverse and innovative delivery methods and international collaborations. When you have equal access to right education and guidance, you can pursue a satisfying career. Did you ever think it is easy to be somebody nobody thought you could be? Are you someone with zero qualifications but a heart full of dreams? If the answer is yes, we transform you into a professional who can add value to the community, society, environment, and the industry you're a part of. Give a life and live a life. What happens to the majority of the students who are deprived of their opportunity for higher education? We strive to give these students another chance to excel in life. We ensure nobody is left behind. Quality is an investment in the future. Our worldwide recognized yet affordable programs are frequently validated by partnering universities, ISO, and regulatory bodies. The student-centric learning methods encourage you to be well-equipped to step into the global workplace and to tackle real-world issues. You will be awarded with a globally recognized qualification to achieve the pinnacle of success. Life is a matter of choices. We are what we choose to be. With us, the choice will always be yours. You shape a better tomorrow for yourself. You must have excellence, but you must also have accessibility to that excellence. That is why we remove barriers and provide the benefits of technology for you. Although innovation is often mistaken for invention, what is the point of an invention if it lacks commercial value? Nowadays, educators are shifting from traditional teaching methods and re-evaluating their teaching strategies, including online learning. And with us, you will have access to an award-winning online learner management platform that has evolved over the past 7 years. Adding goodness to the community is our DNA. And we commit to lifetime education. Coupled with a stronger partner university and alumni network, we are on our way to become the epicenter of healthcare education in South Asia. You may call it a university. We call it home. International Institute of Health Sciences, where opportunities are unlimited.
To set the tone for the evening, let's come in with a distinguished figure in the medical community, holding a PhD Health Science, MBBS, MSc, MD Medical Administration, is a certified master trainer Australia, and is a project consultant for many leading hospital projects in Sri Lanka. Joining HEMAS, he built a chain of hospitals around Sri Lanka. He became a master trainer and trained many professionals, providing them with the skills and knowledge he gained throughout his lifetime. Furthermore, he was a researcher who has done various research and became an entrepreneurial figure by becoming a trendsetter. Using his wealth of experience, Dr. Edirisinghe currently teaches at the Postgraduate Institute of Medicine, imparting knowledge to undergraduate doctors and graduates in healthcare and management. Dr. Edirisinghe firmly believes that his greatest achievement is being able to create a model to include everyone in education. In recognition as an international educator and an entrepreneur, Dr. Edirisinghe was awarded the Asian Grid Entrepreneur 2009 award. He was the pioneer who brought the first international medical programs from the University of Aberdeen, Scotland, to Sri Lanka with the General Medical Council, UK. Moreover, he exports skilled professionals in the healthcare industry and now has begun to export healthcare education to the world by creating Sri Lanka an education hub for healthcare education. In so doing, he closely works with the international industry partners such as National Health Services UK, the biggest health service in the United Kingdom, having over 30 years of experience in the health industry and over 20 years of experience in the education industry. He led this organization, IIHS, to become the only organization providing certificates to doctorates under the nursing specialties in Sri Lanka. Please join me in welcoming Dr. Kithsiri Edirisinghe, CEO, co-founder, and Director of Academic Strategy and International Affairs at IIHS. Over to you, sir.
So good evening to everyone. Hope you can hear me. Today we have two more speakers other than me line up to give you different perspectives in medical negligence. So I will cover from an angle of a medical administrator, and we have Ms. Chiranga Ranasinghe. She's an attorney at law, a corporate law. She has a wealth of experience in the legal field. She will give a feel of how from the legal aspect. And we have Professor Asela Mendis, Professor Head of Department Forensic Medicine Toxicology at Faculty of Medicine, University of Colombo. He will give the views of the forensic consultants. So what I'm going to try to do in next few minutes is to share with you some thoughts how we could look at medical negligence in a more positive and proactive way. Just give me a second. Let's get the proper presentation. Yeah. All right. Hope you can see my screen. Okay, excellent. So let's look at medical negligence overall. Now it's a talk of the town at these days, and there's a media hype and etc. etc. So it's nice to have a simple concepts in your head as a medical professional, and how you can move forward from there onwards. If you look at the human body itself, you all know we have many systems. And when the systems are well balanced, we call it as a healthy body. When the body is imbalanced, we will look at, call it as a sick body, sickness or illness. Then they will come to health professionals, and what we do is we intervene into the body system, try to rebalance the system, just like the mechanic who would change the systems of a vehicle. So what we do, intrude into the body systems, are called interventions. We call healthcare interventions. We do many ways of interventions. We do physical, that's surgically intervene, or chemically, or mentally, or socially. We do a lot of things, interventions as health professionals, in order to rebalance the system or make the sick patient a healthier patient. So in terms of whilst doing this healthcare interventions, there's an enormous amount of risk involved, because that's why we always, when you walk into a hospital, if you ask the doctor or the nurse, can I go home tomorrow? There's always, they would look at it, yes, you can, maybe, there's no straightforward answer to go, that you can go home, simply because healthcare is so complex. So many risks involved. So our whole idea is to manage this treatment, do investigations, and etc., and reduce the risk levels. So there's no guaranteed output. Hospital journey is more riskier than you go into moon and coming back. There's almost 1 in 4 chance. This is according to the literature. You can experience an injury, some kind of a medical mishap, or harm or a death. There's a chance. Risk levels are very high. Could be injuries, accidents, infections, etc. Especially in USA alone, one of the best health systems. So therefore, the healthcare system is very highly unpredictable. It involves many risks. Therefore, it's our duty to reduce the risks. So how to control these risks? What we have done, there are foundations that we have created in order to healthcare risks. So, with reducing the healthcare risks, there's another word coming up called patient safety, making patient safety safe. And of course, different level of procedures. So what we do is we have different policies, protocols. There's a control mechanisms. And in a nutshell, there are 5 main standards or concepts there to control healthcare. What are those? There are legal standards spitting out from the law. There are professional standards. There are professional bodies controlling healthcare. And then organizational standards. There are hospitals that controls healthcare interventions, and clinical standards. That's what we generally learn in medical schools and nursing schools. And of course, there are ethical standards. Those are the 5 main areas that controls healthcare. So what are the legal standards? So there are patient rights, spinning off from the law, rule of law. Then coming off from that, it is delegated to Ministry of Health. From there, the healthcare organizations, training centers, and professional bodies. It has been delegated. I think you can get more info from Mr. Chiranga's presentation regarding law. So then the professional standards. So merely having a degree won't allow you to go and practice, because every discipline has their own controls mechanisms. So medical council, nursing council, allied health councils. So they would give a thing called a registration. So therefore, healthcare is a highly regulated industry. We are regulated because of the risk levels. There are code of conduct given by different organizations. And then you get into the hospital itself. As you have to get permission to have a hospital, and then you have to run a hospital. There are different stringent procedures that we adhere to. And the clinical standards, of course, we all know there are world standards. We have different standards. There's got good clinical practices. So all these will control. Then there's another area which we can't control. There are ethics, because healthcare is no black, no white. It's really, really gray. You can't give a painful injection, black. You can't give a painless injection, white. So how are I going to manage this? So this is where the ethics would come in. So if you really look at ethics, I just want to touch on, I know you all know ethics, but just want to touch on, there are 4 fundamental components in ethics: the autonomy, beneficence, non-maleficence, and the justice. So autonomy is that free will of a patient. He can undergo a procedure, or they can refuse to undergo procedure. Anything. So there's privacy. All these things are private. He gives information to us. We have to keep it confidentially. We can't divulge information. And then we have to be truthful. That's veracity. And then fidelity. We have to work within our scope of work. Each individual in healthcare is given a certain amount of scope of work, the line of demarcation, your area for that you can practice. And of course, the consent. We have to get the willingness of the patient to undergo such procedures. Then the beneficence. Of course, healthcare, as I told you before, it's very great. But there's always pain. There will be risks. There will always be delays. So therefore, whatever matters, I myself, as a healthcare professional, I'll try my level best to do good and do for the best interest of the patient. It's called beneficence, coming from the Hippocratic Oath. Then the non-maleficence, intention to harm more, injuring others. There is a feel of, there is a certain amount of pain, there's a certain amount of damage, but I myself will control that damage to a minimum level. I try my level best to push it towards white, not black. Then the justice, fairness. So this comes in different formats. Justice is it fair to do that? Is it fair to do that intervention? So there are 2 things that we look at: a comparative justice and a distributive justice. Comparative justice is what we compare with the world standards. When you're going to do a procedure, we should do WHO standards, Colombo standards, National Hospital standards. What are the standards that we look at? Then the distributive, okay, you don't have that particular cannula now. Are you going to transfer the patient now? Or are you going to look after the patient? So distributive justice is that with the limited resources that you have, how we are going to manage. So these are is it fair to transfer the patient or you manage yourself? Those are the things that comes in ethics. I just want to touch on this because that is also comes very handy in your when you try to explain medical negligence. Let's get back to the main topic. Medical negligence is untoward, unexpected event that's happening due to human or system error and causing a harm. There has to be a harm, there has to be a damage during an intervention. If there's unintended damage, so there's no damage, there's no case, there's no medical negligence. There are 2 things. One thing is that we do something we are not supposed to do. That's act of commission. Or we are not doing something, but we are supposed to do, act of omission. And that results in an injury. In a most simplest way of explaining this, we are doing something, but we are not supposed to do, act of commission. Or we are doing something, but we are doing something, we are not doing something that we are supposed to do, act of omission. And that results an injury to the patient, right? So this is a global pandemic. People call it as pandemic. Like 3.65 million, 3.6 million patients become victims of preventable medical errors. And it goes on and on and on, right? So it is a part and parcel of the healthcare in a system. And so when you look at the literature regarding the distribution of events, so there are patient falls, there are pressure ulcers about 40%. This is one of the studies that I have looked at: medication errors, suicides, retain objects after surgery, wrong side of the surgery, wrong procedure. So it goes on and on and on. This is during 2007 to 2008, right? I just wanted to get now. Today, it's different because most of the last 2 decades, so many things have happened. Last decade, especially, to improve the safety of the patients. But still, things are happening which is out of our control. So if you look at the law, I think Ms. Chiranga, once again, I'm mentioning her name, she will give you a more insight to the legal in the area. But I would like to just to show you a simple way. This is under it's very common to undergo medical negligence case. It's in the civil courts, and it comes under the law of torts, law of the injury. It's a very common law that is practiced. Any damage, financial law, any other damage, they go under this particular law. And the person who has done the negligence is called defendant. I have to defend it. Then the patient who suffered or damage is called a plaintiff. The plaintiff is the patient and the healthcare professional is the defendant. So then the plaintiff his lawyer has to prove a balance of probabilities that I have done a wrongful act, act of omission, act of commission. I have done that, and then he'll have to show that it's a balance of probabilities. Let's talk about it in a while. And if you intentionally do something, it doesn't go to civil courts, it goes to the criminal courts, right? So what are the simplest way looking at medical negligence? How can my patient's lawyer going to sue me? So there are 4 things that they look at. 4 things. One thing, we call it 4Ds, duty. Firstly, the lawyer has to prove that I have a duty of care towards the patient, right? Secondly, dereliction, that's a breach of that duty of care. I had a duty, I breached that. Third one, because of that, the patient or the plaintiff caused a damage. There was an injury. And then the lawyer has to prove, because of my procedure, because of my negligence, that particular action or act of omission, that relationship between that and the damage is called direct or the causation. So let's take one by one. First one is that there are 2 things that comes under duty of care. When you try to prove a duty of care, I had a duty towards my patient. There are 2 things that they look at. One is how proximal I was to the patient. I was on the duty, I was a duty, or I had given directions to do. So it's called proximity. And then second thing that the lawyer would look at, okay, I was proximal. What was my competence? Was I capable enough to do that particular procedure? So that's called foreseeability. Let's take these 2 together. One, the proximity. This is whether directly or indirectly I had a duty of care. I was how proximal to the patient. So if there was not proximal, somebody else, nobody can sue me. So they check with the health records, they look at the duty rosters, they look at our policy, hospital policies and procedures, and check. That lawyer would check whether how proximal I was. And then my other colleagues. So proximities easily can be checked because of the duty rosters and the BHT and all that documents. It's more of a documentation evidence. The second thing is foreseeability. Okay, I was there. So what was my ability? Did I have an ability to predict such an injury? I know the procedure that I am doing, right? But I have the competence to foresee that there's going to be an injury. So how they do look at that? So they will look at my knowledge. Knowledge is directly look at my degrees, my registration, all that they will look at. The lawyer would look at those things. So knowledge can be somewhat easily looked at. The second thing is they look at my experience. How many procedures I have done in similar manner. Was it my first patient? If at all, who's the one who gave the authority for me to do this procedure? My experience. So that could be by way of CV or way of interviewing. You can check my procedure, my experience. Then the third thing is that you look at whether my attitude. That's a different one to measure, isn't it? How can you measure my attitude? That is the area, most problematic area for healthcare professionals. My attitude will be interviewed by the others. How was that doctor? How was that nurse? How is his general conduct? Has he done this before? He has been horrendous towards the patient. He's shouting at the patient, neglecting patients. So out of all this, the third thing is the most dangerous one, because when there's an incident, they would ask the bystanders, the next of kin, hey, what do you think about that doctor? So that's where the most of the stuff coming out. When you look at some of the cases have been published in papers and the media, you would look at it's simply because the condition could be unavoidable maybe, but that the attitude, how their reaction after the incident and the before the incident has really put a heavy weight onto the case. So therefore, it's importantly should realize that how we behave, how we conduct ourselves when within our healthcare environment. So if there's no, if I was not directly related to this particular case, I will not be part of the case anyway. So second one, breach of duty of care. So I had a duty, okay, fine, I was in the duty, and then I had the qualification, experience, and all that is all approved, that's proven. Then the lawyer has to prove that I breached the duty of care that I had towards the patient. Then there's another word coming in, oh, what is this care? Then there's a word coming called a standard of care. There was a standard expected from me towards the patient. Standard of reasonable care sometimes, because standard is there, but sometimes if you have limited resources, right, like a distributive justice, you will have to look after the patient. So standard of care and the skill what I had already, what have I acquired, and have I done a proper job or at least a reasonable job towards the patient. So what is this standard of care? Again, coming back to, so the breach could be either I did something, but the standard of care also, I was supposed to do A, B, C, D, E, F, G, H. So I did something outside. Somebody is saying, don't do this. Don't give a drug without checking the drug. So I did not check, but I gave. Without checking, giving a drug, act of omission, right? So it's an act. I didn't check, but I gave the drug. Giving a wrong drug is an act. I omitted looking at the whether I looked at checked the drug. So there is not doing things that I'm supposed to do, or doing something but I'm not supposed to do. So both are breaching the standard of care. So so generally the standard of care determined by our international standards, local standards, professional standards. So all these, the 5 forces that I told you, they will check back again. Whether they adhere to the legal standards, whether there's a professional standards to conduct of a doctor, nurse, all that is there. Or organizational standards, or the hospital circulars, protocols, all that is there. Whether I have adhered to that, or clinical standards. That's the one that commonly looked at. But a smart lawyer would look at the others as well. Whether I have taken the consent, or I'm supposed to do that procedure in this hospital. Who gave the authority to do that? And etc., etc. And then, of course, the ethical standards, whether you have adhered to the ethical standards that we discussed. Then the third thing is, okay, there was a standard of care, there was a duty of care, then there was a breach of duty of care. Third thing is, because of that, my breach of that care I was supposed to do, or I didn't do that particular thing, then the damage has been occurred. So damage could be different types of damage. You have so damage is an injury. So it could be physical injury. So you have to amputate the arm or whatever, or extra stay in the hospital, nervous shock, psychological shock that hasn't really come to Sri Lanka. This is the one that loads of lawyers really go after. For the neurological shock, it's intangible. Anyone can say, I get nightmares every day for the last 20 years, and that can be calculated indifferently. Then the economic damage. I lost my hand, I can't do this. Or social and cultural damage. And I don't have a hand. When I go, people call me names, etc., etc., and the social, cultural. It goes on and on and on. But if there's no damage, the case won't go from there. It's essential to have a damage, some kind of a damage. Otherwise, you can't proceed any further. It could be a near miss. I did something wrong, but it didn't happen. Then finally, I had to direct, or I had to show, because of I gave a wrong drug, because of that only, this patient has to undergo amputation of the hand. So this is a reasonable balance of probabilities. They'll have to prove. That's a very difficult one to prove, but that's how it is. But reasonable, the balance of probabilities. I gave the drug because of that only, that has a direct relationship or indirect relationship to the damage that the patient suffered. So it goes on and on. There are several tests you do, the Bartford test and all that, but it's a kind of a technical, but as far as we are concerned, it's sufficient connection between the act of omission or the act of commission that caused the injury. So we'll have to, the lawyer, legal team will have to create a bridge between these two. So, so then who's going to pay for this? So we are health professionals. We have our salary only. But if somebody requested and the court gives maybe 100 million to pay, so we can't pay. So what the legal experts would do, they will sue the hospital. It's called vicarious liability, catch the big fish. So then the legal team would get it from the hospital. Now it is a Ministry of Health, from top to bottom, from the heads to right up to the consultant, and then they will all be responded to the case. The way forward, what can we do now? It's difficult times for all of us. We have a little bit of very minimum resources, and top of that we have economic harangue happening and a constrained environment, very frugal environment, very difficult environment that we are working now. And top of that, there's this whole media hype, and then causing issues, and people will start, what will happen in the whole scenario, we will start practicing defensive medicine. We will check everything. Without that, we will not do procedures. That will add on to burden of the current economic constraint. So way forward, as healthcare professionals and responsible citizens, what we can do is go back to your unit and look at the high-risk areas. It could be a name. Similar names can be pronounced at the theater, and wrong man can go to the surgery. That kind of a simplest way. And look at the previous history where the medical negligence happened and the problems happened, near misses happened. You identify the risk areas in your unit, and then you you validate the risk. There are two ways of validating probability. Check what's the probability. There is a chance of probability of giving the wrong drug. What's the percentage? The second one, okay, it happened. You gave the wrong drug. What's the consequence of that? Because of giving the wrong drug, what happened, right? So then we validate you can put up into a chart, and you can give marks and validate it. If you go to Google, there are many methods how to validate the risk. And then propose an action plan. It's called a risk mitigation strategy, RMS. So you can create a simple solution for that. If the name Siripala and Sirisena, the name is getting confused at the theater, put a color code or barcode or Sirispara, you write on the arm or wherever in a big letters, and then verify it by somebody. So the second one, then you, according to that, you have to put up the protocols. Now, recently I requested in a hospital, I asked them, they take blood, continuously they take blood. I asked them where is the procedure or the protocol saying how to take blood. They were looking up and down. So there is, but you couldn't find. So likewise, we do loads of things, lot of intervention, but it has to be in a paper form. If you don't have, then go and download and then create procedures, standard operating procedures. If you don't have, the simplest thing. interventions where there's a risk. Then finally, reporting mechanism has to be, we have to monitor and get a reporting mechanism weekly, and notification mechanism if this incident happen, what we are going to do soon after. Then put that into performance appraisal. Then communication to the staff is very important, to be very open, not to hide. If you hide, the tiger will come one day, and a big way. When the tiger comes, we will have problems. Then when you look at the there's a procedure called open disclosure. If you go to Google, you can see how there are two ways: minor procedures, minor incidents you do in a different way. You react. Major issues, you react differently. So open disclosure is another one that the international organization, the foreign countries are following up. It's very good. Once it comes, you identify the risk levels which you haven't identified before, and you take action regarding that. And most importantly, we have to be competent and very confident at the end of the day, and caring health professionals. That's it from me. Let's hear from the other panelists. Thank you.
Thank you, Dr. Kithsiri Edirisinghe. Moving forward to our next speaker, she possesses over 25 years of experience at the Bar Association and was admitted to the private bar as an attorney at law of the Supreme Court of Sri Lanka upon completing her tertiary education at the Sri Lanka Law College in 1994. She holds a diploma in Human Resource Management from the Institute of Personnel Management of Sri Lanka and a Master of Laws from the University of Colombo. She currently heads corporate law chambers and independent legal practice active across business and commercial law, banking and finance, land laws and conveyancing, company law and company secretarial practice, trademark agents, civil litigations, and commercial arbitrations. She served as the external legal consultant for 3M Lanka Private Limited, assisting in compliance, business support, commercial documentation, and government procurement procedures and documentation. She currently is an independent non-executive director and also serves the chairperson of the Board Related Party Transactions Review Committee and a member of the Board Audit Committee and Board Nominations and Remuneration Committee of RIL Property PLC. Please welcome Ms. Chiranga Ranasinghe, Attorney at Law at Corporate Law Chambers, University of Colombo, Sri Lanka. Over to you, Ms.
Thank you. So hello, everyone. I think Dr. Kithsiri gave a very informative session. I will share my presentation now. Can you see it at the moment? Can you see it?
Not yet. Not yet.
Let me see. Can you see it now?
We can't see it. Chiranga will ask the technical
team.
Yeah. Just give us a minute.
Yes.
Yes, now we can see. Yes.
Right. So good evening, everyone. So I will give an overview of the legal aspects of this medical negligence. Unfortunately, the law regarding medical negligence is not very developed in Sri Lanka. We are still with the Roman Dutch law, and we are going with the concept of torts, law of torts. So negligence is a common term in any profession, right? As Dr. Kithsiri explained, it's an omission or a commission by a person, like doing something that you should not do or not doing something that you should do, which will ultimately cause physical or economic or even mental or emotional damage to another person. The legal definition is actually from a 1856 case, which has been reaffirmed in 1957. It says, the case is Blythe versus Birmingham Water Works. It says the omission to do something which a reasonable man, note the word reasonable, guided upon those considerations which an ordinarily regulate human affairs would do, or doing something which a prudent and reasonable man, again the word reasonable, would not do. Now, medical negligence is a special branch. It leads to complaints about the adequacy or inadequacy of a care given to a patient. Now, it's also called, now, there is, in negligence, in medical negligence, there are two aspects. There's a civil aspect and a criminal aspect, but I will mainly go with the civil aspect, because to prove criminal aspect, we have to prove a mens rea, that is a mental element of willful doing. So the medical malpractice is of course a professional negligence, where, like Dr. Kithsiri said, an act or the commission or an omission, act or an omission by a medical professional, where the treatment provides falls below the accepted standard of practice in the community, the medical community, and causes injury or death. Now, because of the private hospitals and private medical care that is available to patients in today's society, the patients want the best care. Now, generally,
Excuse me, Mr. Ranga. Mr. Ranga, the slides are not moving. Sorry.
Is it moving now?
No, not yet. Sorry about it.
Okay.
Okay. You can stop share, and again, if you go back, I think it should be.
Okay. Right, I will share again. Share the. I'm sorry about the glitch. Shall I share the entire screen now?
Yeah, we can see it now. If you get a full screen,
Yeah.
nice.
Is it moving?
Yeah, I can see the third slide. If you can
All
go
right.
to the, yeah,
Right.
put it in the slide full screen mode, it'd be right nice.
It is on full screen.
Okay. You can continue, Mr. Ranga. That's fine.
All right. So, okay. So I'm on the third slide. I was now, as I said, because of the the emergence or the growth of the private medical industry, unlike some olden days where only mainly the government hospitals were available, and medical professionals were put on a pedestal, and everything was delivered without and taken without questioning. Now, in today's society, patients look for the best care. But again, there's a tendency in the medical professionals to treat the errors as human errors. So Now the courts have an issue where they want to give a satisfactory solution to the victims while also allowing the doctors to work without fear of litigation, like in certain countries, in jurisdictions like America, where everything is the doctors are very restricted in taking risks and experimenting or doing something innovative. And now there's this emerging concept of patient autonomy and patient safety. So therefore, there is a big debate on this issue. Now, all patients have a right to satisfactory, good, standard medical care and aftercare. This does not happen all the time. So, therefore, the victims, the patients who are suffering loss or damage, have a right for compensation for a lot for the loss they have suffered, if they can prove that there was medical negligence. This rationale of awarding financial compensation is, that's the only thing that you can offer. I mean, in a civil lawsuit, you can't put the medical professional in jail. So the only thing that can be offered is financial compensation. But in an issue where there is death, there's no compensation for that. So it's generally for to renew the financial loss. So generally the courts award compensation for physical or mental damages. Now, as Dr. Kithsiri said, he went into detail. I will just touch on that because my presentation will not be complete without touching on this. So to establish a claim of negligence, the victim or the patient must prove 4 things, like Dr. Kithsiri said, that the medical professional owes a duty of care to the patient. The moment the professional takes on the patient, the duty of care starts. Then the second one is that there was a breach in this duty of care, or the proper duty of care was not exercised. Then the third one is the professionals, medical professionals' act or omission, doing something or not doing something, caused the patient to suffer some loss or damage. And the fourth one is that the loss or damage was a direct cause of the professional's breach. It cannot be something that could anyway have happened. It has to be the direct result of the breach. So it is the victim or the patient's responsibility to demonstrate all these 4 components in a claim. Then the patient must demonstrate that the negligent care resulted in some sort of compensable injury. So what is a medical professional's liability? There has to be a duty of care. Then there has to be the breach of a standard of care, which is, as Dr. Kithsiri said, dereliction. Then there has to be an injury. And the injury would have been foreseeable. So reasonable, it has to be reasonably foreseeable, the reasonable foreseeability of that injury. So when a medical professional attends to a patient, he owes the following duties. the duty of care in deciding whether to undertake this case. Now, having said that, it's easier said than done. Now, in a private medical institution, this is possible. A medical professional can decide whether to take on the patient or not. But in a government hospital or in an instance where they are the only available medical professional, this is not that easy. Then the second duty is the duty of care in deciding what treatment to give. Again, there may be different treatments available. Different doctors would decide on different courses of treatment. So if the professional can prove that the course of treatment that he decided on was the best course of action that at that time with the available resources that he could have taken, then that duty of care has been discharged. Then there is a duty of care in the administration of the treatment. Again, as I said, there could be different standards or different methods of administration of the treatment. But again, that it has to be done with the utmost care or the care a reasonable person with the same qualifications, the same experience and expertise would do. So the breach of any of the above gives the right of action or negligence to a patient. The next important issue is the reasonable degree of skill and care is indicated on the part of the medical professional. And of course, as there is no 100% guarantee of success, but anything that was not done or anything that shouldn't be done was done, an omission or a commission would worsen the patient's condition. Having said that, medical professionals are also humans. They don't have to give out of the greatest level of care. The current standard is that, then again, the minimum degree of care is also not enough. It has to be a care where another person, a reasonable professional, medical professional, not another person, but another professional with similar experience and expertise would give. That is the standard expected. And now, a mere slip or a mistake, sometimes we call it human error, will not contribute to negligence. There have been instances where mistakes they tried to term mistakes or as a mistake as a negligence. I will give you a couple of examples of the standard necessary for the law. So the standards necessary will differ according to circumstances. For example, a severely injured person bleeding. Just a minute. There is will you excuse me a little bit? Hello? Can't see the slides moving. Oh God. Just a minute. Okay. I'll try. Slides are not moving, I hear.
Excuse me, Ms. Chiranga.
Yeah, is it okay now?
It is. If you could press the presentation button that is right at the bottom next to the zooming panel. It's towards your left.
Yes.
Could you see that there's a button?
Says I'm sharing. See, stop share. Can you see the moving? Can you see my screen?
No, Ms. Chiranga, we cannot see your screen.
I'm so sorry, I'm taking your time.
Fine.
That's okay.
So I'm sharing my window and share screen. Can you see it move? No?
Not yet.
If you can stop share and select the PowerPoint, go for share screen and just pick the PowerPoint area window which is open, that will be great.
Yes.
Share screen.
I'm trying to share the window. Okay, and entire screen. Share.
Yeah, now we can see. Yeah, now it's moving. Yeah, now it's moving. Excellent. No.
All right. Thank you. I'm so sorry about the delay. Now, I was talking about a couple of examples where the standard necessary for the law, how the standard necessary for the law would differ depending on the circumstances. Say where a severely injured person with severe bleeding would, if he seeks treatment from a rural hospital, which lacks a lot of facilities, even though the medical staff puts in the maximum effort and treats the patient, and if still the patient dies, that would not amount to negligence because the medical staff has given the best care that was available according to depending on the circumstances. Now, an instance where maybe a newly qualified doctor undertakes a duty, that doctor is not expected to perform at a level of a physician. However, it will be negligent if the doctor holds himself out to be or having the competency of a senior specialist in the field. So there's a clear demarcation. It's the standard of skill and care that is required or given should be of the quality and competency of a similar, a peer, not above, provided that you disclose that you are of this competency. In now, as I said, we have Roman Dutch law in Sri Lanka where medical negligence, we fall back on the Roman Dutch law because we don't have a enacted law. Now, I will just mention here, our laws are either we have a myriad of laws. We have Roman Dutch law that we inherited from the Dutch people. Then we have, luckily we don't have much from the Portuguese, but we have the Roman Dutch law from the Dutch, and that is still our common law. Then after that, the English came, and we have English law in certain other aspects. And then when we became a sovereign state, we enacted our own laws. Even during the English, we enacted laws, or we had the Queen's laws. And then in our parliament, we enacted laws. And we also have customary laws. Canadian law, Thesavalame law, Muslim law. So there are customary laws. And there is another way that we have laws, that is by decided judgments. If a case is decided in court, that is in the Supreme Court, because after the Supreme Court, there is no other place to go. So if it is in a lower court, a person can appeal the judgment and it can overturn. But once after the second appeal, when it goes to the Supreme Court, that becomes law, because those are dicta. We call them dicta. So we look at Supreme Court judgments. If we find anything lacking in certain areas, we check to see whether there are judgments in that area of law. So here in medical negligence, we have to go by the Roman Dutch law, or then we have to go by any dicta, any decided cases. So in Roman Dutch law, the duty to exercise reasonable care arises when a medical professional should have reasonably foreseen the probability of a harm by his action or inaction, act or omission, except maybe in instances where the ability to foresee was not there and it can be justified. Then the Roman Dutch law also requires when the test is under the Roman Dutch law is now the standard of care. Was there a standard of care the professional was supposed to give at the time of this negligent act was committed? The next question is whether that standard was given. Was there a standard of care required? Whether the standard is given. Now, negligence is not determined by the lack of skill of the professional, right? But he's undertaking to work without a skill. So, lack of skill is not a fault, but the decision he takes to work without a skill. Now, this was the dicta in one of the landmark cases called Arskoratna versus Disorisa. I will come to that in a little while. So there are different standards, these different tests that are done by the judges. If you go to court, if somebody goes to court on a medical negligence thing, the judges will perform some tests to see this standard of care. Now the legal expectation is that the professional will provide care consistent with his training and skill. That similar to another person would do in the same circumstances. If, however, a person holds himself out to be of a higher level and training, he is expected to provide the treatment consistent with the standard that he is saying that he has. Now, this Bolam test was actually decided in Bolam versus Tryon Hospital Management Committee. I said 1957 case. I'll just read out. A medical professional is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art. Putting it the other way around, a man is not negligent if he is acting in accordance with such a practice merely because there is a body of opinion who would take a contrary view. This Bolam test was highly criticized because it does not take patient interest into consideration. So they came up with another test. It's called Bolito test. Right? It is more practical. Of course, this case, Bolito versus City and Hackney Health Authority, which is a much recent case in 1997, this is a more pragmatic and practical approach. It has a logical aspect to it. Whether if one person, if the medical practitioner took a decision to do something or not do something, whether it has responsible peer support based on an approach that was structured, reasoned and defensible, that others would also take that same view. The second stage is the risk analysis. That is to assess the validity of accepting the treatment by the patient and validity of rejecting anyone objecting to this or competing opinions. So whether the person would consult the other practitioners of the same caliber, or whether he would reject any competing decisions. Then Dr. Kithsiri mentioned about causation and damage. So there has to be a damage, not a perceived damage, an actual damage. That this damage has to be directly connected to the medical professional's action. And the patient has to prove, the burden of proof is with the patient to show the judge, that the damage could not have occurred if not for this action. The law, as I said, the law related to medical negligence is the law of delict. The liability under the law of delict is twofold. There are two liabilities under the law of delict. One is the Aquilian action, that is the civil aspect of it. And the other one is actio injuriam, that is the criminal aspect of it, right? So for the civil action, you need to have evidence of negligence. Then that there was carelessness or deliberate misconduct. No accidents. And there was a loss that was suffered. For the criminal aspect, there has to be evidence of deliberate and motivated action, ill will, which causes damage to person's dignity or repute or body, right? So that is a different arm of the law, which by that mens rea, the criminal action, the mentality is there to harm the person or kill the person. So that is the criminal aspect of it. Now here, I just mentioned that there are two arms in this law of delict, but I'm concentrating on the civil part of it. So the obvious redress available for a person suffering a medical negligence injury is a civil action. Of course, there are other public law options where there is under the Article 126 of the Constitution, there's it can be a violation of medical basic rights, because there under the Constitution, everyone should have access to treatment. So the proper treatment. So we can argue that there was no proper treatment or improper treatment. So there are other actions that can be taken under the public law. And now Supreme Court urges fundamental right applications, instances where the basic liberties of people have been violated. There are other options also. We can file a complaint with the Sri Lanka Medical Council, which I think the Human Rights Commission very urges that they do that. Then you can lodge a complaint with the police station in case of a major injury or a death. That's the criminal aspect of this. You can also complain to the Public Services Commission to take disciplinary action against state employee. You can complain to the Ministry of Health for disciplinary action, or complain to the Human Rights Commission. But these are all these things lack transparency and take time and expertise and money. So as I said, the law in Sri Lanka, we fall back on the Roman Dutch law for the concepts, but there had been a decided case, a landmark judgment about medical negligence. That is the Arsakuraratne versus D'Souza case. Now, I am sure everyone knows about this case, where the plaintiff, he was a legal luminary, D.N.C. Arsakuraratne, consulted Dr. Priyani D'Souza, who was a well-known, very popular pediatrician at that time, to treat his 4-year-old daughter. Dr. D'Souza diagnosed the illness as rheumatic chorea and recommended that she be warded. The child's condition was rapidly deteriorating, so Mr. Arsakuraratne sought a second opinion, where he was asked to quickly take the child to UK at that time, and where it was diagnosed that it was too late, or it was decided it was too late for any intervention. The child died 2 months from being first presented to the defendant, Dr. Soiza. Now, Mr. Asaguram, having access to the highest legal personnel in the country, filed a case asking for medical expenses, which were rather high at that time because she had to be flown to the UK and back. And then he was asking for damages on account of mental shock. Then for loss of future earnings and support from his daughter, that something he would have got if his daughter had a full life, and damages for loss of care and companionship from the daughter. However, now this case went all the way up to the Supreme Court. Now, it was filed in the district court, then thereafter appealed to the civil appellate court, and thereafter further appeal to the Supreme Court. Now, fortunately or unfortunately, this is the dicta that is available at present. That means this is the law that was decided in Sri Lanka. Many of the cases do not, many of medical negligence cases do not go to court. Now, we see so many in the media. Because of social media, there's a lot of dialogue about this. But unfortunately, very, very little medical negligence cases go to court, and very rarely to Supreme Court level for it to become dicta. That means for it to become law in this country. Most of the cases that go to court are settled in the lower courts or out of court. It is never generally, after this Asagurnath case, there's only one case which I will explain. There very rarely cases go to Supreme Court level for it to become law. Many reasons for that. One is our people have a mindset that say that they fear going to court. I don't blame them, because going to court would be a huge erosion of on your finances, adding insult to injury. It will take a long time, and most people would not be in a situation or would not have access to the legal luminaries, and it will of course be very expensive to go to court to that level. So a lot of people do not go to court, and they would take some financial settlement out of court. So back to Arsapuram case, when it went to the Supreme Court was unanimous in its judgment. Supreme Court would have 3 judges, and this judgment, all 3 judges was unanimously given. The judgment said the defendant may be guilty of professional negligence. Yes, she did not do what she should have done at the onset itself. There was an element of negligence, probably it was there. But the defendant's negligence in treating the child did not cause her death, because the child would have anyway died, maybe after some time, because the child was terminally ill. So the plaintiff there failed to establish causation. That is the connection, the causal connection between the defendant's negligence and the patient's death. Right? The biggest shock was this: the plaintiff was not liable for damages on any of the above claims, not even medical expenses, which was a bit of a setback. The other three, I understand, because anyway the child was terminally ill and child would have died. Yes, there may have been negligence, but that was not the cause of death. So the causation was removed, but there were medical expenses. Then again, there would have anyway been medical expenses, because they wouldn't have kept the child at home during that time. So this judgment came under severe attack. This judgment is being criticized even to date, right? So now the child had died. So the child was not the claimant. Child was not the petitioner. Now the injury was done to the child, but child couldn't have come to court. But child's parents came. The dead person cannot claim damages for obvious reasons. So what was decided there was that since the child was terminally ill, they could not establish causation. He would have died irrespective. Then about damages for loss of income and all that, since Mr. Asela was, if you can say, affluent, he was the Solicitor General. So he, being an affluent relation, cannot claim damages as they have enough resources. If he was a poor relation, he couldn't have afforded the litigation costs. Then the loss of companionship. If you remember, I'll just go back to the earlier slide. The plaintiff asked for medical expenses. Plaintiff asked for damages on account of mental shock. Damages for loss of future earnings and support, and damages for loss of care and companionship. So now future earnings were not relevant because he was affluent. Loss of companionship was irrelevant. So that was what court decided. So now Dr. Shivaji Felix, in his book of Snakes and Ladders, he said, one down for the Roman Dutch law, one up for the medical profession with this landmark case. This case has significant far-reaching implications for the future, still does. In the first place, due to the nature of the test of causation adopted by the Supreme Court, it would be that no one could sue a negligent medical specialist on behalf of a patient who is terminally ill. Why? Because the terminally ill patient would anyway die. Secondly, it means that a parent cannot sue for damages due to the loss of a child unless the parent was in indignant circumstances. Mr. Asela was well off, so he could not sue for damages for loss of income. So this is a highly unlikely situation if the present parent is a professional or any other person who can afford to have his or her child treated at a private hospital. So when you go into trial, when you go to court, medical negligence cases are notoriously challenging to win. It takes a lot of time and cost a lot of money. Now, while being highly mindful of medical practice in regards to medical malpractice, the courts appear eager to uphold the integrity of the medical profession. Because That's a very, very specialized field, and any decision cannot be given lightly. Now, in the civil actions, the 4 elements we mentioned earlier have to be proven by balance of probabilities, and the burden of proof is with the victim. As I said earlier, in most of the cases, parties come to some sort of settlement on a negotiated basis. Because going into, as I said, going into litigation is costly, because probably both sides will have to call in expert witnesses, which has its consequences and which would cost a lot of money. The burden of proof of medical negligence lies with the victim, because those are specialized fields. Law demands a stronger proof, and in most cases, there's contributed negligence or ignorance on the part of the patient. So the lawyers have a field day, and outcome is not satisfactory. I will, however, in this light, I want to tell you about a recent case which had got the headlines. You would have seen the headline, child wins with 30 million in landmark medical negligence judgment. This case, you would have heard of this case or read about this case. It was just decided last year after more than 20 years of silence. The Colombo District Court delivered this judgment, awarded 30 million compensation to a child whose disabilities were a result of negligent conduct of the hospital and medical professionals at the hospital at the time of her birth. So the judgment was dated 13th September last year, awarding 30 million rupees to this child. This case established causation, the link between the child's injury and the conduct of the medical staff at the Gampa District Hospital at the time of the child's birth. The action named the Secretary of the Ministry of Health and the Attorney General as the respondents, the defendants. In this case, 581 DMR, that is District Money Recovery, of 2014. Now the judgment was given only in 2022. So that proves my case, how long it takes just at the primary court level. This is just the district court level. Now this can go to 2 other different levels. The plaintiff in this case claimed, the plaintiff is the child, the disabled child, appearing by a next friend. That's called, like, you know, when a minor has to go to court, the court has to appoint a guardian who's called a next friend. So the mother is the next friend. So the plaintiff, the child, is claiming that the medical staff ignored her mother's complaints or unusual symptoms at the time of delivery, which was on 14th May 2012. The child had the umbilical cord around her neck, which obstructed the flow of oxygen to the brain, causing brain damage, permanent brain damage. Now the child has permanent disabilities, frequent seizures, speech disability, movement disabilities, and needs 24-hour care. And most importantly, the child cannot lead a normal life. The issues that were raised in court. Now, when you're filing a case, when you're fighting a case, you have to give court a certain set of questions where you seek answers from court, or court has to find answers to these issues. They are called issues. Some of the issues are whether the hospital staff have a duty of care towards the plaintiff. Now we are coming to the duty of care. Has the hospital staff failed to exercise the duty of care towards the plaintiff and her mother? So we are talking about the breach of care. Has the hospital been negligent? Will the plaintiff have to spend the rest of her life as a disabled child? So the damages. Now we're talking about the damages, and whether the cause of action has accrued to the plaintiff against the defendant. Whether the negligent action was a direct, the damage was a direct result of the negligent action. So all these above questions were answered in the affirmative. That means the case has been proven. Court also said the doctors have agreed with the Director General of Health Services to treat all patients that walk into a government hospital, despite no payment being made, and that they have a duty of care. The doctors have failed to conduct a CTG for 10 minutes. That I believe is monitoring the baby's heartbeat. They have failed to conduct a scan to ascertain whether there's a cesarean is required. The mother has been continuously complaining about unusual symptoms, which has been informed. And court noted that it only takes about 30 to 45 minutes to set up an emergency cesarean, which was not even done. And the nurses have been exceptionally harsh to the mother, and all this pointed to there being a breach in the duty of care owed to this patient. And to top it all, there was a specialist who gave evidence at the trial, who confirmed that the disability of the child would not have occurred if the hospital has exercised due care. So the result was that the plaintiff managed to establish the causal link between the disability and the conduct of the medical staff, and the plaintiff was entitled to compensation. But what do you expect? They have appealed this judgment. Now it will go to, it's a final appeal. So it will go to civil appellate court first to see whether this judgment was reasonable or has any errors. And if it is again in the favor of the child, it will go to the Supreme Court. So I am thinking it will take another 5 to 6 years for this matter to be finally decided. So the legal aspect that is currently here in Sri Lanka is not desirable, to say the least. We need proper mechanisms, proper laws to address this. In light of the fact that medical areas are becoming very, very commercialized, we need stringent procedures, stringent laws to stop malpractice. And I think, this is my personal view, of course, that probably not the medical professionals, probably not the doctors, but there is a lack of competency in other areas in medical caregiving. I think that's what Dr. Kithsiri is trying to prevent or minimize. So I think I've rambled on enough. I'll be happy to answer any questions anyone would have. And we'll listen to Professor Asela.
Thank you, Ms. Ranasinghe. Our final speaker for the evening, Professor Nandita Asela Mendis, with an MBBS, MD in Forensics Medicine, DLM, Diploma of Legal Medicine, Diplomat of the American Board of Medical Legal Death Investigators, USA, IIHS, CEDA, UK. He's a professor in the Department of Forensic Medicine and Toxicology since 2004. Faculty of Medicine, University of Colombo. I shall allow him to introduce himself further. Over to you, Professor.
Okay, thank you. I hope you can hear me.
Yes, Professor, we can hear you.
Just a second. Can you see the screen?
Yes, Professor, we can see the screen.
You can put in the full screen.
Oh, from my just sure. So I can't see it.
Yeah, you can
Probably it's
get off and yeah, unshare the screen and then again try again.
extended. Is it okay now?
We can see the screen, Professor. Could you put it on to presentation mode?
You see only the first slide, is it? I have two screens here with me. You see two slides or one slide?
We are seeing the medical negligence slide.
Right, so that's correct. Right. Okay. Thank you for inviting me for this webinar. When Kithsiri, my long-time colleague and batchmate, asked me, so I agreed amidst of very busy schedule. I think, but anyway, my task has been made easier because most of the things that I wanted to say already told by Dr. Kithsiri and Chiranga prior to me. So, though I run through my presentation, I will try to elaborate certain things which has not given in the PowerPoint presentation to concentrate about various unexpected situations and the problems that the doctors might face and the other consequences.
Excuse me, Professor Asela.
Yes.
Could you full screen the PowerPoint?
Sorry.
Could you put the PowerPoint on full screen? It's right at the bottom next to the Zoom bar.
My one is on full screen. Maybe. You see only us.
We see only the first slide.
Now it didn't move, is it?
Did not move, yes.
Why is that? Just a second. Just a second. Now can you see?
Not yet, Professor. We still see the first screen, the first slide.
First slide. Now? Go.
Still the first slide.
Is it okay now? Did it move?
Yes, it did. Now it is okay, I guess.
Right. Okay. Okay. So
we have this also for full screen. This is...
my one, of course, it's on full screen. That's
It's okay. We'll move on. Asela, it's okay. If you can.
just a second.
Play it here.
I find it difficult to find because it's in my monitor, it's on full screen. All the others also have the same problem.
Yes, Asela, what you can do is, as long as it moves, it's fine. We can see the part of it.
Now, can you just tell me where to get it full screen? Start video, move, show.
Professor Asela?
Yeah, how to get it for full screen? Just tell me, I'll just try it once.
All right, are you having two screens?
Yeah.
All right, in one screen, do you have the full screen?
Yeah, one is on the slide, slideshow view. Other one, I have the current slide and the next slide on with the. So I think this has come up. I have to reverse it.
That's right.
It's the other way.
If you could reverse the screen.
Just a second. I'll. Is it okay now?
Yes, it's okay now. Thank you, Professor.
Right. Okay. Right. Okay. Sorry for the delay. Now, just Now, talking about medical negligence, I think I don't have much to say about the medical negligence, how it caused, but I'll stick to the basics. And now, professional liability could be sought when someone suffers personal injury as a result of medical treatment. So, the doctors, especially the nurses and even any other medical staff, is very vulnerable in today's society and the current under the current situation or the allegation of medical negligence commonly. Though, so Chiranga said the legal uh, people sorting for legal action is very much less. But I think that with the current trend, actually it might the situation might escalate. Now, when a physician agrees to diagnose or treat a patient, it is said that he assumes a duty of care towards that patient. So, as Kithsiri said earlier, now duty of care is established at that point. Now, if someone, the practitioner or any other health staff personnel fail to meet that duty of care, or what is the standard of care which he or she is supposed to provide to the patient, that can result in someone claiming for negligent act. Now, depending on how the doctor or the nurse or someone else deals with the patient, even rarely or occasionally, this negligence might even amounts to criminal negligence. And especially in certain situations, something can be done with malicious intent as well. We can't totally exclude such thing. Now, as a person involved in medical legal practice, we often get cases, both clinical and autopsy, referred through the routine procedure for medical legal examination. So there are a lot of cases. There will be definitely legal consequences, not with regard to especially the doctors, but like a homicide, road traffic accident, many things are usually ends up in the court. So therefore, when we are also doing medical legal work, we also should be careful to do our job properly and provide a standard expected medical legal care and management for the patient. Now, this is not, I'm not talking about the managing and treating patients in the ward setup. And we also come across cases where there's already a bit of a chance of medical negligence, allegations of medical negligence. Now, if you all know that in the recent time, there are many cases which have come up in the media in various ways, that there are a lot of and different means of medical negligence being alleged of. Right. So therefore, when you are dealing with such cases also, we have to be very cautious, because as medical legal personnel, whether it is doctor's fault or not, or whether it is a fault of any other health staff member or not, we are bound to produce unbiased, true report to the courts, because one day we might have to go to courts and give evidence. So therefore, our reports, opinion should be unbiased, and we usually, as medical legal practitioner, we will not consider who the accused party is, right? So that is about the medical legal situation. So because it can include not only civil negligence, even criminal negligence, and even the presence of any malicious intent as well. And it is also should be noted that when there's some negligence on the part of a medical professional has been alleged of, the plaintiff or the clients have the opportunity to complain even to the medical council, Sri Lanka Medical Council, and also as mentioned earlier, even Human Rights Commission and even the Employer Public Service Commission and the Ministry of Health. So there are a lot of maybe a complicated issue when you take a single case. Now, as Dr. Kithsiri mentioned earlier, right? So the element of causation of this negligence or malpractice arise from these four things. I think this has been now repeated earlier. I don't want to go into details, but just to summarize: duty of care, the negligent or breach of duty, causation, and damage. So when someone is complaining of medical negligence, they have to prove all these four and also the connection between 1 to 4. Now, about the duty, now what is the legally, what is the legal relationship between the defendant and plaintiff that will support the tort claim? Because now we have to, the law has to decide whether the duty has been established, duty of care has been established between the doctor, the medical personnel, and the patient. Now, if you take a different situation, maybe the government hospital, private hospital, and other medical services, each of these situations gives rise to different perspectives. Like now, if you take for example, National Hospital, the patient comes to the accident service, consider a patient who met with an accident, comes to the accident service OPD first, the initial examination, history taking, the investigations done there. Then, if necessary, they will admit the patient to the on-call ward. Now, the moment he comes to the ETU or the accident service and the patient is taken to the doctor, that duty of care that will at that level is established. Now, sometimes a problem arises. Now, the patient is taken from the ETU or the accident service OPD to the ward. Now it might take few minutes to transport the patient from ETU to the ward, right? Now, someone might raise a question: who is responsible for that period, right? So that will be again like a gray area where you have some difficulty in determining who has the responsibility. And therefore, even the hospitals, whether it is private or government, has to address those issues as well. Because you can't have a system running, at least even one part, where you cannot find a responsible person, right? So they are maybe very difficult practically, but these issues might crop up in certain cases. Now the question is, if the doctor lays hands on the patient, is there a duty, right? So usually what we say is, the moment he is brought into the ward, even before his name is registered in the ward inpatient register, just since he has been transported or sent by the same hospital, same OPD staff to the ward, the moment he enters the ward, that duty of care, I don't say that directly between the doctors and the patient, but at least the institutional wise care is established duty. And moment a doctor or a nurse goes and talks to the patients or the bystanders and start dealing with the patient, that duty starts. So therefore, when the patient comes to the ward, I think there is no issue about the establishment of duty and when it is done so, right? So therefore, that is one. Then there may be a situation, a question arise whether this duty can be terminated at any point. Now, if it is a government hospital or private hospital, the moment to admit the patient to a ward, you can't simply terminate and turn down the patient and send him back, because you've been under certain procedures, the patient has been admitted, right? There may be certain issues of treating with regard to the medical staff, but you cannot just refuse to treat and send the patient back. So there's no, no one can do it. But if we are considering a situation where a patient comes into a general practitioner's private clinic, there may be a situation that the doctor doesn't want to treat that patient and advise and turn him back and send him to somewhere, some other hospital or other medical facility. So that is about the start of duty of care between a doctor or medical staff and the. Now, next question is how broad or how narrow this duty is. Now, question is a specialist consultant responsible for the patient's entire condition, or can he or she rely on the primary physician, or else whether how much duty and care responsibility falls on the rest of the staff. Again, I don't think that there's any definitions or tables giving the percentage of responsibility falls on different categories of medical staff in a ward or the hospital. But definitely the more responsibility falls on the doctors, then the nurses. As it goes down, the responsibility, the maybe percentage-wise reduces, but it's always all the staff attached to the hospital or the particular ward or get involved in treating the particular patient has some degree of responsibility. So therefore, this act could act in a different way. Like all might be held responsible, but then someone is particularly, someone makes allegation in a particular person, maybe a doctor or a nurse, he or she might have the can go for a defense about the degree of responsibility he or she has towards this patient. Now, certain instances in government hospitals, right? Sometimes now, when even the on-call doctor might not be available right at that moment when the patient is brought to the ward. So therefore, these are for all practical reasons that they will contact the usually doctor over the phone and get advice or get the doctor down to the ward for examination. So therefore, so there may be issues arising from this instance as well, because if someone tries to manage the patient on phone without seeing the patient, right? So that there's a very big risk involved that you might get wrong information, or might you get the information but you might interpret in a different way because you haven't seen the patient, right? Or else there are maybe instances that there's a delay of the doctor coming and attending the patient, right? So therefore, talking on the phone and trying to manage the patient on the phone could give rise to serious problems. Definitely, when you're first informed, there's no option other than that you are giving the preliminary advice to the rest of the staff about the patient to do certain things till you go and attend to the patient physically. But when it comes to medical negligence, all these issues, all these practical situations can give rise to unexpected problems later on. Now, there may be another set of medical persons having like limited engagement with the patient, like occupational medicine, right? Say a doctor visiting a institution or or factory to attend to the patients or the ill people on a daily basis or weekly basis, right? So this doctor or it may be a nurse will have a limited time of contact between this, right? So therefore, practically, there is a possibility or risk a doctor or the nurse missing certain medical condition or certain things because they have a limited time to engage with the patient and maybe limited resources. So that there may be a situation that either you misdiagnose or miss the diagnose and come to a wrong diagnose, or those things that come with, and the patient getting serious consequences later, and they might later make allegations against the physician or the doctor or the nurse who attend to them at the employer's place, right? So therefore, even now someone has to consider what is the duty of a physician who do physical examination and limited treatment for occupational injuries or other illnesses in a during a limited engagement, like a day, few hours for a day, or maybe a day, few hours for a week at least. Then nowadays we have this ambulatory care center. So ambulatory care medical services where doctors sometimes giving opinion and instruction over the phone, or sometimes they visit homes and do some sort of medical treatment, right? So what is the role played by them and what is the duty they owe to these patients, right? Because sometimes in a serious illness, this patient may be transferred or admitted to government or private hospital later. And by those situations might cause serious complications and even death later, right? So someone, relations or family members can go back and can make allegations against the people who under this ambulatory care services or centers who attended the patient maybe few hours or days back at home, right? So therefore, when a medical negligence case comes up involving this type of case, there are a lot of people, a lot of medical practitioners, a lot of healthcare professionals might get involved in different stages, and each one might have a role to play, might have some duty towards a patient. So it might cause a very complicated situation, and probably it's even at the court of law, it might cause a very complicated situation and make the life of even judges difficult to come to a certain verdict or decision. Now, then there are certain instances, and now what if these people who attend a factory or employees or working in the ambulatory services, but if they notice something beyond their engagement or beyond their competence, right? So the doctor or the nurse might see or diagnose a certain condition where he or she knows that he or she is incapable of treating or attending. But as a health personnel, for the betterment of the patient, best interest of the patient, they might try to do certain things, and which might go wrong, and they might fall into trouble. So these are real practical issues that one should consider when we are talking about the duty of health staff towards a patient and the degree of duty, and also when we are trying to determine who is responsible, how much he or she is responsible, and whether someone has breached the duty of care with regard to the patient in certain instances. And apart from that, there may be like invincible physicians or doctors get involved in the care, especially someone like radiologists, pathologists who read their X-rays, CT scans, MRIs, or do their pathological investigation and interpret report. Now these comes in like inward patients, the reports are attached to the BHT, and the physicians or surgeons take decision depending on their reports, right? So which usually goes unnoticed in the case of like serious allegation against about medical negligence. Only the people or the doctors and staff in the ward is highlighted, right? Now, even at the moment, there are few cases going on, right? There may be a lot of people involved, medical staff involved in the management, but only few categories are highlighted, right? But now, these people looks like invisible physicians, but they also owe a duty, and they also sometimes they could held responsible for certain instances, like for wrong interpretation and wrong opinion given based on reports, those things. And there are maybe instances where consultants or doctors who do not come and examine the patient, right? These things have happened earlier. It will happen in the future, right? So however much we say, or however much directions or circulars are sent by the Ministry of Health, how many standards operational procedures we develop, there will be still people, right, including doctors, consultants, and even other medical staff who will not attend to the patient and do the necessary, that they might postpone it, right? These things have happened. It will happen. So therefore, then what is the situation if you come across a situation like that? A doctor has not come and examined the patient at all. And there may be a physician who review or supervise the care for other physicians in training program. Now yesterday also, we had a discussion at the Ministry of Health regarding maternal death. Now, there is an issue that mainly in the periphery. Only one consultant in a particular hospital, and when he goes on leave, who takes the responsibility? Who take the responsibility to transfer the patient? And how are going to transfer the patient? And what is procedure? So there are gray areas where the lack of resources, lack of facilities also play a part. So therefore, certain instances, it's not only the doctors or the health staff, maybe the institutional responsibility that falls on the cause of medical negligence. Going into now, what is I think both Dr. Kithsiri and Chiranga both talked about the applicable standard of care in medical practice, medical malpractice cases, right? So now with regarding to professionals, all of them are supposed to provide a standard of care according to their qualifications and experience. Now, with regard to the professional standards, it is said as a reasonable, prudent, and a prudent physician of ordinary skill will do. Right? So therefore, we go for the minimum acceptable standard of care when you are dealing with a medical negligence case. You cannot individualize most of the time because there will be other factors coming into play. Then again, there's a reasonable patient standard as well. What a reasonable patient in similar situation would expect. Now this being in a digital globalized world, patients or people can Google and find a lot of information about certain disease or management plan. So they might have a high expectation or even a unrealistic expectation about the standard of treatment that they should receive. So therefore, there may be a gap or problem between the standard of care provided by the medical staff and the standard of care expected by the patient, right? So they have to really go and even to find whether these standards expected by the patient is really whether it's realistic, because we live in a situation that so the doctors and nurses are highly qualified, experienced. It may be the lack of facilities, resources that ultimately determine what the patient gets. Now, for example, now these days, there are a lot of commotion going around about the substandard use of substandard drugs and injections, right? I mean, during the past few weeks, there are a lot of cases, a lot of allegations, even a lot of deaths related to the use of particular drugs or injection. In some instances, it is they are very about the particular standard of the drug or the quality of the drug. And now, if it is like a quality of the drug, the question comes: who is responsible? Right now, doctors do get involved in recommending drugs and approving, but the procedure of getting a drug from a local company or a foreign country goes beyond that. And a lot of other people involved. So if it is the substandard drug, the quality of drug that result in the damage to the patient, question comes: who is responsible? And now, usually, in a case of medical negligence, court will determine or try to ascertain the case or decide based on expert testimonies as well. Now, for a medical negligence case, the court might have to call another expert or maybe more than one expert on the same field to get their opinion about the standard of care and to get an idea about whether there actually there's a breach of care happened in this particular situation. Now, the next question is to answer the question whether was there any breach of this standard of care a doctor or the health professionals supposed to provide the patient with, and whether it is a negligent act which has breached the care, and coming to negligence, now it can occur in different stages or different ways. One may be a misdiagnosis, right? That may be due to the inexperience or the qualification of the doctor. Then failure to, even after diagnosing a particular case, failure to properly treat, right? So now the misdiagnosis takes a case in a different direction. But if it is properly diagnosed and still fail to properly treat, then it goes in another direction. Then administering the wrong medication, right? Sometimes not only administering wrong medication, doing a wrong surgery on a wrong organ or wrong site. Right? There have been few cases, right? Even like surgeries done on the wrong site and patient suffering. So then it might even goes towards even a criminal negligence in that particular case. Then sometimes a failure of informed consent, right? So it's a patient's, as Dr. Kithsiri initially said, the autonomy of the patient, where you have to safeguard the privacy, confidentiality, and the patient's right. So the patient, if he's an adult, and also if he's incapable, the next of kin, the family members have the right to know what happens. So all medical procedures, surgical procedures, you are bound to give their correct, valid information and get their consent to proceed with the future of further medical or surgical management. Now, to tell you a story about this informed consent. Few years back, in a very popular private hospital in Colombo, there was a patient admitted. I think he was in his mid-60s, patient with the Parkinson's, admitted for, I think, as I remember, from cardiac catheterization process. He was, yes, signs and symptoms of Parkinson's, but he was conscious and rational. He was okay. He was communicating well, right? And he was admitted for investigation. Then the doctors suggest to go for a cardiac catheterization, for which he did not. He didn't want to go with the procedure. He said, "I'm fine. I'll take what it as it comes, because I don't want to go for this." Right? So he was very stern. So what the medical staff, I don't know who instructed or what actually happened. When the next day wife came to see the patient, husband, a nurse came and told her that they want to do some further investigation, and got her signature for the procedure. And then they went ahead with the procedure, and patient never recovered from anesthesia. Right? So this is a situation, I don't know why it happened and how it happened, and whether they knew about the rules of consent, so on. They took wife's consent when the patient was conscious and rational, went for it, and he never recovered, and he was in a vegetative state for about few months and died of, I think, pneumonia later. Right? So it's like a point blank case of medical negligence where they have taken the consent in a wrong manner, which is not valid. Right? I don't know what happened to this case. I don't think that there were any legal action taken by the family, because according to the wife, she has consented, so she has nothing to complain about. And fortunately, unfortunately, most people do not know about these rules and regulation about consent. So probably in there, but it is a totally wrong procedure they have got. And like administering wrong medication. Once I did a case where about mid-20s patient, boy, who met with an accident, has a fractured tibia fibula, treated in the accident ward, and they wanted to do a MUA under general anesthesia, but the patient has some problem, so they delayed the procedure. But the patient was on augmentin right throughout. I think he was admitted somewhere mid or late September that year. He was almost on augmentin for almost 3 years. And then one day, the house officer saw a reddish rash the patient, and he diagnosed it as hypersensitive allergy to amoxicillin. So augmentin, you know that it's a type of amoxicillin. So he omitted the drug, and it was written in red that to omit augmentin. Then a week after, patient was taken for surgery. So in the theater, consultant anesthetist went through the ticket and said, how could it be augmentin? Because this patient has been in augmentin for 3 weeks, should be something else, can't be augmentin. So as a pre-medication, patient was given a shot of augmentin in the theater. The other consultant anesthetist was present. And within few minutes, patient developed an allergic reaction. And he almost collapsed, but he was managed promptly, and he came out of it and he was fine. Now the situation, now the amoxicillin or augmentin allergy is confirmed because he has been having reaction twice. So he was sent back and was in the ward. And another month later, they did the MUA without anesthesia, under local anesthesia. And following the day following the surgery, now the two nurses going around the ward giving the drugs. And as a habit, sometimes they use to draw the drugs before going doing the ward down, keep it in the trolley. And one reads the drug chart, other one gives the. And so when it came to this patient, one nurse took the drug chart and went on reading, and she accidentally read says augmentin 500. The next moment, she realized that there have been augmentin has been omitted. It's written in red in large letters, amoxicillin allergy. And then she said, no, not augmentin. But unfortunately, the other nurse has already given the augmentin shot, which has drawn, drawn and kept on the trolley. And the other patient says that the second who gave the injection, she didn't have time to take the needle out when the patient collapsed. And unfortunately, they was a doctor in the ward, but they didn't say what happened. And only after 15 minutes that the doctor was told that he was given a shot of amoxicillin, and doctor realized this is high allergic and gave the drugs 15 minutes later, but it was too late. He has brain damage, on the vegetative state, and died of pneumonia a few months later. So there is if you are not cautious and careful, there may be many instances in the ward, especially in an emergency situation, that you might fall into trouble, giving the wrong drug or doing the wrong procedure or doing a correct procedure in a wrong way. So therefore, even the recent cases which has come up in the media, right? Maybe most of the things are avoidable, right? So therefore, when breach of duty and there's allegation of medical negligence, should know these are the things that give rise to negligence, and you try to avoid and educate people, then there will be less trouble. No one wants to get hurt and go to courts and get compensation, but the people really know to stay healthy without falling into unnecessary trouble. No one will wish when they're coming to the hospital that someone give me a wrong drug and I get a reaction, then I can go to courts and get compensation, some millions of rupees, right? So people, almost all wants to get the proper treatment, cure themselves and go home. And sometimes if you are grossly negligent and breach of duty, causing medical negligence can happen in one of these as a result of one of these A's, right? So if the doctor practices any of these, like adultery, addiction, alcohol, unnecessary or wrongful association with unqualified people in treating patients, and commit or do abortions, or even advertising, that again amounts to medical negligence in certain ways. I will skip these two slides, which deals with the Bolam test, which was discussed earlier, right? And also the criticisms, everybody, I think Chiranga has already gone into detail, so I will skip it. Now, as a rule, once it has been shown that a physician or a male health staff being negligent, a plaintiff must prove the negligence caused and the harm caused by it to the courts. So it's the onus of proving lies with the plaintiff. So the Negligence Act, as told earlier, must be directly responsible for the harm, or sometimes in cases it might at least have contributed to the harm. Right? The compensation will change according to what has happened. Now, these are if the plaintiff establishes negligence and liability, they are entitled for damage. So there'll be compensatory damage. Then there may be non-economic damages patient suffering from, but still may be compensated with money, right? So as Ms. Chiranga told that there are very few cases in Sri Lanka, but other countries, you have enough cases to show examples on different case scenarios. Now, again, for example, now in Canada, they have a medical insurance scheme for all health staff, including doctors, nurses. And it is a must that they get the membership that the government run insurance scheme. Because once what happened when a few doctors or health staff been accused of medical negligence, the rest will automatically push towards a defensive practice. Right? You try to defend yourself rather than trying to treat the patient properly. Right? So I don't think that it is a good thing to happen. If you go to a defensive practice, then the patient will not get the expected care, because if it is me now, I'm doing a defensive practice. My primary intention to safeguard myself for my interest. So therefore, I might not do certain things that should be done. And especially in emergency situation, sometimes doctors, health staff might have to take a risk. That is like inbuilt in your service, right? And in an emergency, though you are the most junior, one of the junior doctors, in the emergency to save the life of the patient, you might not have time to consult anyone else. You might, knowing that you don't have the expertise or the qualification, you might have to go one step beyond and do certain things that you routinely that you are not supposed to do. But I think if you do it in a proper way to save the life of the patient, then even someone makes allegations about your act, you should be able to come out of it without much problem. Because if you are like genuinely done it for the best interest of the patient. So how we should avoid without going or pushing towards inappropriate defensive practice. Avoid allegations, because that is what pushes medical staff, medical personnel toward defensive practice, which sometimes will be inappropriate. So 1 to 5, first thing is you have to make a clinical sound treatment decision as far as possible. Then also you have to accurately identify the legal risks you are dealing with in a particular case. Then, as a practice, you evaluate the risk by estimating the potential cost of claim and time, anxiety, money with your experience and what the patient should receive. Right? So if the patient's life in danger, right, you might not get the other, consider the other facts seriously, but you do whatever necessary to save the life of the mother, life of the patient, right? So therefore, you might, in instances, might have to face troubles or allegation, but if you have done it genuinely, to the best interest of the patient, you should be able to come out of it. Then, other risk calculations and the decisions and evaluation the cost even to the patients, like, should be done in a case of medical negligence if you are really get involved into. Then, as I think Dr. Kithsiri mentioned, most of the things could be settled out of courts, right? Even if you have done something wrong. The first thing is you have to be genuine, you accept, right? And you have to report or resolve the conflicts as close to the bedside as possible. And keep accurate, contemporaneous records of all clinical activities. What we say is you treat the patient, also treat the PhD, right? Note down, document every act you do. You might have to do it retrospectively being just after the procedure, not 2-3 days, 1 week later. You document everything, because you might do everything that is necessary to save the life of the patient, but if you don't document it properly, no use. Someone goes to courts, you don't have anything to prove and say that this is what you do, this is why you did it. And also in cases like if you know that you are there's impending negligence cases, even notifying insurance and seeking assistance. And sometimes if you take the lead in disclosure, without waiting the patients or relations of the patient to ask, you might be able to settle it without going to courts. And also in that situation, always have an outline plan of care to rectify the harm and prevent recurrence. So if you do it properly, most people will accept, right? And offer to get from second opinion wherever possible. So you make a mistake, do a wrong act, but you try to discuss it with the patients and the relations and sort it out. And also offer the option of the family meetings and get professional helps to conduct them. Because without running away, I think if you discuss certain things, that will be very, very easy. And document important discussions, and be prepared for a strong emotion. People will react in different ways, but you have to be prepared for it and accept responsibility for outcome. And but try to avoid attribution of blame, and apologies and expression of sorrow whenever appropriate. So it's not like when you do something wrong or you miss something, that doesn't always mean that it ends up in legal consequences. Most of the things you can sort it out. I have done it, not for me, but for someone else. When I was about long time ago, maybe 25 years ago, when I was a surgeon, a patient dying of a pelvic fracture bleeding. And I was on call SHO, and the house officer never informed me. He tried to manage and he died of hemorrhage. And so when I went there, it's a big commotion and they are threatening to go to police, make complaint. But then I managed to talk to them. And I managed to convince them that even, because they were alleging that why this patient was not transferred to a tertiary care. So I managed to convince, and then they accept that the patient would have died anyway. So therefore, they dropped the charges, right? So even a serious consequences, you might be able to sort it out. Because now there's a recent wave of alleged medical negligence, like treating and using substandard drugs, misdiagnosis, so on, right? So as the time goes on, this will escalate definitely, because there's a media playing a big role in like creating these stories and making like a situation where there's making you create a prejudice situation among the general public, which will be very difficult to change, right? So we don't have to try to change it. What we should do is we do the correct thing, But in my opinion, even the media has a big role to play. A few years back, there was a full page article, as I remember, in Sunday Times, where a girl in mid-20s or 30s was transferred from Coroner to Colombo following a road traffic accident with head injury. So they were, and in Colombo, after doing MRI, those things, the consultant neurosurgeon decided that it is beyond treatment, right? You can't do anything, and she's going to die. So what they did was they didn't have a ventilator. So they, after initial investigation management, they transfer the patient back to coroner, where just after receiving the patient back in coroner, they diagnosed the patient to be brain dead. And with the consent of the parents, they kept her on ventilator to harvest organs for donation with the consent of the parents, right? So once they prepared, now the patient is confirmed brain dead, so they harvested the organs, right? And they to be transplanted to few other patients, right? So this came up in the paper, saying, make allegation that the organs were retrieved or harvested from a living patient, because the person who wrote that article considered patient to be alive simply because she was on the ventilator and the heart was beating according to the machine. But at that time, it has been pronounced brain death, and they simply kept the patient to harvest it. And there's another allegation and saying that apart from the patient, no one can give the consent to harvest the patient. I don't know from where they take these things, right? As everybody knows, when someone dies or when being on ventilator, you take the consent from the next of kin. So in this case, he was a unmarried girl. So the parents consented. So there was nothing wrong about the procedure or what happened. But the totally false story came up on papers, right? Now this is being escalated now because it now goes in the social media, YouTube, right? So once you give the wrong impression, it's very, very difficult to change the prejudice situation that you create among the general public. So we have to be very, very careful. As doctors, we have to be very, very careful. As legal professionals, we have to be very careful when we are dealing, because you are maybe dealing with a totally different case from what is being told and or shown in the media itself. So that is one message that I want to get across, right? So as strong, I mean, even if you are giving some information to the media, you have to get them to write the real picture, not what they think or what they expect. But
Excuse me, Professor Asela.
Yeah. That thing, okay, now it's that is the message I want to give, right? Because I deviated a little bit from my presentation because most of the thing I was prepared to tell you all was already discussed. So I think that's it. I will stop sharing the slide. Then I think if there's any questions, we shall be able to answer now.
Professor?
Yeah.
Yeah, we do have a
Yes.
question. What is the difference between balance of probability and providing beyond reasonable doubt? I think that was a question for Ms. Chiranga.
Right.
Yes. Now, a balance of probabilities would be where a reasonable, when you lay down facts before a reasonable person, that person can make a reasonable judgment based on the facts that has been presented to that person. In most of the cases in court where evidence is presented, most of the cases are decided on a balance of probabilities. If one party proves something a little bit more than the other party for a reasonable mind, that would amount to a balance of probabilities. Beyond reasonable doubt goes a step further. Now, for example, now you may have heard in divorce proceedings, one ground for divorce is adultery. Now, these things have far-reaching consequences. So, the burden of proof for adultery would be beyond reasonable doubt. That is, you cannot leave room for there to be another argument. So that's the difference between the burden of proof of on balance of probabilities and beyond reasonable doubt.
Thank you, Ms. Chiranga.
I can I add something? If someone is interested about to find the difference between beyond reasonable doubt and balance of probability, I think one good case is to read about the O.J. Simpson case, where the criminal litigations ended up that he had been acquitted because they couldn't prove the case beyond reasonable doubt. But in the civil case, he was convicted. He was asked to pay compensation because it was a balance of probability.
I think that's all. But any other question? I think and all the panelists. It was a long day for all of us. I think we should thank all of you and as well as the participants. Any comments or last, final comments, anyone? That's it.
All right. And that brings to the end of this session. The webinar session recording will be shared to you as a link into your email. Thank you, everyone, for your active participation. With that, we come to the end of this session filled with knowledge and sharing. I want to extend my gratitude to all of you for being such an attentive and participative audience. Have a good evening. Thank you.
Thank you.
Okay, thank you very much.
Thank you. Bye.